Well, hello. So I am now back. I'm going to go through this joint pre-trial order. Let's make that a bit bigger so people can see it, including me. um, okay, so this is 22 pages long, obviously give or take. Shouldn't take too long, but I haven't read this yet. I'm looking forward to it. All right. Okay. So, pursuant to Section 5A of this court's individual practices in civil cases, Plaintiff Blake Lively and defendants Wayfarer Studios, It Ends Worse Movie, and Tag, together with defendants and together with Miss Lively, the parties, through their representative counsel, jointly submit this pretrial order. Yeah, so this is where they kind of like, this is our position, and this is Wayfarer's position, this is our position, and they have this kind of back and forth. But basically, they have jointly put together this document. So, although it was filed by Gottlieb, it does actually come from Wayfarer as well. So, I'm going to start by the full caption of the action. Oh, I like that. The full caption of the action is set forth above. So, initially, what this is doing is setting out who's doing what, who's going to appear, etc., etc. So they're starting with the trial counsel. Who is going to be at trial for the parties? And for Lively, a lot of people. So from Manat, there's going to be Ezra Hudson. The new attorney, Nyan Rim. I hope I'm not butchering that. I usually do, but apologies. I'm not quite sure, but that is obviously that's the new counsel that joined the docket recently for Lively. We have Stephanie Rosa, Sarah Moses, Serene Armani, Caitlin Climaco, and then we've got Matthew Bruno. Now he's separate because the first set of lawyers are Los Angeles lawyers for Manat, and then Matthew Bruno is actually a New York lawyer for Manat. And then we got Wilkie, Gottlieb, Corin Bell. They're from Los Angeles, really? I'm sure wasn't Gottlieb a New York attorney? And then Kristen Bender, DC. And then we've got Michael Schachter, Aaron Nathan, Michaela Connolly, Melissa Taustine. They are the New York firm. I was convinced that Gottlieb. I'm going to have to go and look at that now because that is going to annoy me throughout the rest of this if I don't clear that up in my brain. No, he is actually Los Angeles and Washington. Okay, that's fair enough. I stand corrected. Oh, so he's admitted to the bar for New York, California, and Colombia. Okay. Fair enough. I don't like his face, though. He irritates me. Right, okay. That makes a lot of sense. Let's get back to this. Dan Isaacson, that's Meryl Gavernsky. Now, obviously, she was initially under, I want to say, Wilkie. She was under either Manat or Wilkie, but she moved to a different law firm, but she has remained as part of Lively's team. What is interesting that the person who is not here is Sigrid McCauley, who at this point I'm not sure if she's Lively's attorney or her spokeswoman. But she's not there. Trial counsel for defendants. So we've got Brian Friedman, Ellen Garofalo, Kim Zeldin, Amir Kaltgrad. And then from Shapiro, so they're from Friedman's firm. From Shapiro, you've got Alexandra Shapiro, Jonathan Bach, and Alice Buttrick. So obviously, Friedman's firm is a Los Angeles firm. Shapiro's firm is New York. You've also got Meister, Seelig, and Schuster. And that would be Mitchell Schuster and Kevin Fritz, who I adore. They're New York attorneys. Subject matter jurisdiction. The court has subject matter jurisdiction over Miss Lively's claims because the matter in controversy exceeds the sum or value of $75,000, exclusive of interest and costs, and no defendant is a citizen of the same state as Miss Lively. The court additionally has supplemental jurisdiction over the claims asserted, pursuant to Section 1367. Okay. Claims and defences to be tried. Miss Lively's claims. Miss Lively's remaining claims to be tried by the jury are as followed. Retaliation. Miss Lively asserts two claims for retaliation. One, a claim for a retaliation in violation of the FIHA against Wayfarer and It Ends With Us movie. And two, a claim for retaliation against It Ends With Us movie in breach of the protections for return to production agreement as described below. Miss Lively will show that she complained about or otherwise opposed hostile work environment sexual harassment at multiple points in time, including the filing of her administrative complaint in December 2024. Right, that's that was not a complaint, right? Yes, she filed the administrative complaint, right? But they didn't investigate anything, and she also put it in the New York Times. So I mean, within the law, yes, she's right, but it annoys me because that was not filed to give Wayfarer an opportunity to, look into or resolve her complaint. That was filed because it needed, litigation privilege for the New York Times. Come on, we all know this. Miss Lively will also show that Wayfarer and Ensworth's movie anticipated that she would engage in further protected activity in response to and or in an effort to interfere with or inhibit Miss Lively's ability to engage in said protected activity. Wayfarer and Ensworth's movie unlawfully retaliated by seeking to undermine Miss Lively's character and professional reputation, discouraging and obstructing her ability to complain about the hostile work environment, attacking her professional reputation, including but not limited to by orchestrating a smear campaign against her in the press and on social media, which included painting Miss Lively as a bully, tone deaf, and a mean girl. Oh my God. And the source of friction on set. but it's all true. And to be fair, the world said she was tone deaf. It wasn't just Wayfarer. The world said she was tone deaf. Threatening and or attempting to intimidate Miss Lively and third parties. Who? Third parties? Who? What third parties did Wayfarer attempt to intimidate? And filing a frivolous and legally improper retaliatory lawsuit against Miss Lively and her husband. The retaliation inflicted significant damage to Miss Lively's professional reputation and career prospects. Aiding and abetting. Miss Lively asserts a claim against defendant Tag for aiding and abetting retaliation in violation of California Government Code, Section 129401. Miss Lively intends to prove Tag knew that Miss Lively engaged in a protected activity by complaining about or opposing sexual harassment and substantially assisted or encouraged Wayfarer / Ensworth's movie in their retaliation against her. Okay. Breach of contract. Right. This one bothers me, and I'm gonna talk about that. I'll read it, but I will talk about it as well. Miss Lively asserts that Ensworth's movie breached the protections agreement, which unequivocally prohibited retaliation against Miss Lively for her raising complaints against for her raising complaints regarding inappropriate and harassing on-set conduct, including by Justin Baldoni and Jamie Heath, including any changes in attitude, sarcasm, marginalization, or other negative behavior, either on set or otherwise, including during publicity and promotional work in connection with the film. Okay. Now we're going to have a little conversation. Have you noticed there, right? Miss Lively asserts that It Ends With Us movie breached the protections agreement. So she is saying It Ends With Us movie, not Wayfarer, not Justin Baldoni, not Jamie Heath, not Steve Sarowitz, right? Specifically, It Ends With Us movie, right? Why is she specifying that It Ends With Us movie breached the protections agreement? Let's go to a post on X that I prepared earlier. I've been screaming about this now, and I'm going to say it again. I wrote this post yesterday. Let's imagine that Wayfarer's renewed motion for summary judgment and or the motion for judgment on the pleadings is successful, and the retaliation claims and the retaliation claims are dismissed, right? That would leave the breach of contract claim regarding the contract rider. So this is a 17-point extortion list. I have made this argument before. I'm going to say it again because I think this is so important, and I'm slightly annoyed that Wayfarer have not raised this. Why is no one talking about this? People need to be talking about this, right? The contract rider agreement was an individual agreement between the Ends With Us movie and Blakell Inc., not Blake Lively in her individual capacity. Let's look at this. Actually, here. This is the signed bit at the bottom of that 17-point list. It Ends With Us movie, right? Acknowledged, agreed to, and accepted, right? You got It Ends With Us movie is a signature. The name of the person who has signed it is Jamie Heath, and his capacity is president, right? But Jamie Heath is not personally part of this agreement in his individual capacity. He has signed it on behalf of It Ends With Us movie. Then you've got over here on the other side, the other person who is, part of the agreement, the contracting party. Blakell Inc. It is signed by Blake Lively. In what capacity? She is the authorized signatory. That does not mean that she is a party to the agreement. She is not as an individual, right? And I'm about to show you, because Wayfarer basically made a very similar argument, okay? So here's the cause of action. This is from Library's second amended complaint. The cause of action that is still in: breach of contract rider. I'm going to make it a bit bigger. The first paragraph in orange, right? 426. The contract rider agreement is a valid and enforceable contract between Blakell Inc. and It Ends With Us movie. Now, she does put Ms. Lively was the intended beneficiary of the contract rider agreement, i.e., only that the benefit was that she would not be harassed anymore, and she would get to pick producers, composers, and control Isabella Ferrer's nudity rider and all the other crap that, basically she wanted for her PGA letter. But let's put that aside, right? The agreement is between Blakell Inc. and It Ends With Us movie. And then she has to state, well, Blakell Inc. has complied with all of their responsibilities and, their burdens. So here in green, Blakell Inc. has complied with all applicable provisions of the contract rider agreement. And she's saying that because what she's saying is, look, Blakell Inc. has done what they said they were going to do. It's Wayfarer, It Ends With Us movie who has breached the agreement. And it wasn't literally It Ends With Us movie who breached it. It would have been like Justin Baldoni, Wayfarer. So as much as It Ends With Us movie as a corporation, right, was responsible for the actions of, Wayfarer Justin Baldoni, etc., employees and cast and various things to keep Lively safe, not do this, not retaliate. Yeah. And Lively saying, well, it ends with movie. Well, they did all that. Ainsworth's movie didn't actually retaliate. She's saying Wayfarer retaliated, technically. I mean, right. I mean, she is saying, oh, yeah, she is trying. I don't know why she's arguing it, but she's saying Ainsworth's movie did retaliate. But obviously, when we're talking about the retaliation, what is that? That is, well, who actually hired Jen Abel? Not Jen Abel, Melissa Nathan. Who hired Jed Wallace? Was it Wayfarer or Ainsworth's movie? Do you know, like, there's going to be a lot of pulling apart the detail of this. But basically, she's saying Wayfarer slash it ends with us movie. So she's taken all, keeping everything and putting all her eggs in a basket, right? And she's saying this is who retaliated against me, and as a result of potentially Wayfarer being the one who retaliated, or Justin Baldoni being the one who retaliated, she's going to point to Wayfarer. She's going to point to the individual Wayfarer parties too, including Jen Abel and Melissa Nathan and Jed Wallace, who never were part of It Ends With Us movie. But by their retaliation, it breached the contract, is what she's saying. And It Ends With Us movie had responsibility for keeping all of these people and this other corporation in check and not allowing them to do it. So, by the same standard, though, the obligation was on Blakely Inc. for Blake Lively to do her part. Yeah? But, just come out here. Is it this one? No, it is this one. Okay. Wayfarer, in the motions in limine, actually made the whole argument, right? In terms of Lively's lost profits and lost royalties. I know I'm going on a bit of a... Bear with me, right? And I'll show you what I mean. And what they've said here is, however, a shareholder such as Lively, because Lively is suing in her individual capacity for lost profits and lost royalties, but it wasn't her that the losses, if you can call them that, she didn't personally suffer the losses. It was her entities, her business entities. Okay. However, a shareholder such as Lively cannot sue in her individual capacity to redress wrongs inflicted upon a corporation in which she holds stock. An individual lacks standing to sue when the alleged injury is based on an injury to a corporate entity, right? Courts routinely reject claims like Lively's in which individuals seek redress for corporate damages, including lost profits. As explained in Gray Gables Corp, Ali and Jones, neither Lol Hatter's nor Lively's share of lost profits is recoverable as damages because Lively lacks standing to seek damages suffered by the companies. Right, and then there was another part as well. Lively is the plaintiff, not Lol Hatter. Therefore, she lacks standing to seek damages for lost royalties to Lol Hatter, and the court should exclude all evidence and argument regarding lost profits. A shareholder, even the sole shareholder, does not have standing to assert claims alleging wrongs to the corporation. And this is what I am arguing here. Right? If I keep going, right, in the motions in limine, Wayfarer made the argument that Lively, as an individual, could not claim loss of profits that her corporate entities suffered as an individual. She has no standing, and the positions are not interchangeable. So, should that breach of contract also be tossed? And I go on to say, I think so, and I'm internally screaming at Wayfarer to make that argument because it was Blakely Inc. who contracted with It Ends With Us movie. It was not Blake Lively. And Wayfarer have made the point in regards to the lost profits, etc. And we went through all the agreements. It was Lol Hatter, and with Blake Brown, it was Family Hive, and she may be part of these, companies or shareholders, but that does not mean she gets to sue for the lost profits and lost royalties. She can't, because she has no standing. And I actually made this argument the day on April 2nd, the day the judge's order on the motion for summary judgment came out. Because when I was going, if you go back through my videos, I did a video where I had up Blake Lively's second amended complaint, and I went through the causes of actions, and it was a brief video where I went, right, that's out, that's in, that's out. And it was when I got to I didn't say it in that video, but I have done a video since on it. I think it was which one was it? It was a troubling point. It was my second follow-up video, actually, where I went into more detail about the order. And I raised this point then, and I will raise it till the end of time. But this bothers me, and I think that and Lively knows that. I think Lively does actually know, and she's hoping that it will just, again, slip by. But she's asserting that it ends with us movie breached a protections agreement. But she can't claim damages for that as an individual. Only Blakel Inc. can. So I'm hoping someone raises that, because that claim would then go. Right, now thank you for humoring me. I'm just feeling like no one is really talking. Why am I the only person mentioning this? Why am I the only person talking about this? So yeah, make sure you guys all talk about it though, and say point this out to anyone who listen, because I do think it's important. It gets rid of another claim, basically, which I think is kind of important, because that's. I mean, I don't know whether Wayfarer want to keep that contract rider in. They might want to, actually. That might be the whole point. And they may point this out in trial, but they may want the contract rider there so they can say, well, on the surface, it looks like, she needs this to keep us safe, but why does she need another producer of her choosing? And, why does she need an intimacy coordinator when she knows damn well we've already got one? Why does she want control of someone else's nudity rider who's a fully grown adult when she took months to sign her own nudity rider? It may be that they want to make those points. So I don't know. I'm not sort of sitting in on the strategy planning here, but that is very possible. Okay. Previously asserted claims. Ms. Lively previously asserted additional causes of action which are no longer at issue, including for sexual harassment. And I'm trying to put my charger in my laptop and it's not working. Under Title VII, FEHA and California Civil Code 51.9. Failure to prevent harassment, retaliation under Title VII and California Labor Code Section 1102.5, aiding and abetting as to Jennifer Abel and Melissa Nathan, breach of the ACTA loan-out agreement, false light, defamation, civil conspiracy, and intentional and negligent infliction of emotional distress. Pending motions. Sanctions. Ms. Lively has moved for spoliation sanctions against Wayfarer, Innsworth Movie and Tag based on the use of the ephemeral messaging platform Signal. Ms. Lively respectfully submits that the spoliation motion should be decided in advance of May 2026 trial, given that such matters may substantially affect presentation of the evidence and other trial matters, such as jury instructions. Ms. Lively's motion for attorney's fees, treble damages, and punitive damages under California Civil Code Section 47.1, filed September 8th, 2025, similarly awaits a ruling. Ms. Lively submits that the 47.1 motion should be decided in advance of the May 2026 trial and renews her request that, if granted, the court should set a schedule to promptly quantify the monetary award to which Ms. Lively is entitled pursuant to Federal Rule of Civil Procedure 54D2C. I would be very surprised if Judge Lyman decided that the 47.1 motion before the trial. He might, but I can see him, like, because if she loses, she doesn't get them anyway, so it would save him having to go through all of that. Okay, so the defendant's defenses. The following claims asserted by Ms. Lively in her second amended complaint were dismissed with prejudice by the court. 1. Sexual harassment under Title VII. 2. Sexual harassment under FEHA. 3. Sexual harassment under California Civil Code 51.9. 4. Failure to prevent harassment and retaliation under California Government Code, Section 12940. 5. Retaliation under Title VII. 6. Retaliation under California Labor Code, Section 1102.5. 7. Aiding and abetting as to Jennifer Abel and Melissa Nathan. 8. Breach of the Act Alone Out Agreement. 9. False light. 10. Defamation. And 11. Civil conspiracy. In addition, in lieu of responding to discovery concerning to Ms. Lively's alleged intentional and negligent emotional distress claims, Ms. Lively dismissed those claims. All individual defendants named in Ms. Lively's second amended complaint, i.e. Justin Baldoni, Jamie Heath, Steve Sauritz, Melissa Nathan, Jennifer Abel, were dismissed with prejudice. And let's not forget, Jed Wallace and Street were dismissed, not with prejudice. She can refile, but she hasn't. She can't refile in New York. She has to take it somewhere else. Therefore, of the original 15 claims set forth in Ms. Lively's second amended complaint, only 3 survive. 1. Retaliation in violation of FEHA against Wayfarer Studios and It Ends With Us movie. 2. Aiding and abetting FEHA retaliation against TAG. And 3. Retaliation in breach of the Protections Agreement. In its summary judgment order, the court withheld judgment with respect to TAG's liability for aiding and abetting retaliation and granted TAG leave to renew its motion for summary judgment. The defences to Ms. Lively's remaining claims to be tried by the jury are as follows. Retaliation. Ms. Lively cannot prove the elements required to establish retaliation under FEHA against It Ends With Us movie and Wayfarer Studios. Wow, they went straight for the jugular. Lively did not oppose conduct that she reasonably and in good faith believed to be discriminatory. Rather, she used her experience on set as a cudgel for control over the film. In addition, no aspect of Ms. Lively's employment changed for the worse after any of the alleged protected activity. Ms. Lively cannot establish that defendants' public relations efforts were linked to protected activity, were substantially motivated by discriminatory intent, or were the proximate cause of Ms. Lively's alleged damages. Ms. Lively's argument that defendants retaliated against her because they anticipated she might engage in further protected activity does not make out a viable claim as a matter of law. Defendants' public relations efforts and countersuit are not actionable as retaliation because they were undertaken as reasonable defensive measures in response to Lively's own efforts to destroy defendants' reputations and careers. As the court noted, to be sure, much of what Lively complains about is not actionable. I love that. Defendants were entitled to 1. Engage public relations and crisis management specialists to protect their reputations. 2. prepare responses to the protection letter and the accusations that it implied, including the right to assert that the claims against him were untrue or misconstrued, and that Lively could not be credited, and the right to convey why Lively's account could not be trusted. 3. Use proxies, both disclosed and undisclosed, to defend him or herself. Aiding and abetting. Ms. Lively cannot prove that TAG can be liable for aiding and abetting or that it engaged in conduct that aided and abetted retaliation in violation of FEHA. Breach of contract. Ms. Lively cannot prove that Enter This Movie engaged in conduct constituting retaliation for raising concerns described in the protection letter. Damages. Ms. Lively cannot prove damages on several grounds, including because no quantifiable harm resulted from the conduct Ms. Lively complains about. Ms. Lively has disclaimed anything other than garden variety emotional distress claim. Ms. Lively cannot claim damages flowing from separate corporate entities. Ms. Lively's claimed lost wages and reputational damages are the product of her own conduct and or other factors, and Ms. Lively cannot prove that punitive damages are warranted against any defendant. Failure to mitigate damages. Even if plaintiff can establish retaliation was a substantial motivating factor in the adverse action, defendants will establish that legitimate non-discriminatory reasons would have led it to make the same decision at the time. Further, Ms. Lively could have avoided some or all harm with reasonable effort. Yeah, talk about domestic violence. That would have helped. Donate. She wants to bring in evidence of her husband's charitable donations to places like the NAACP, I'm sure, and maybe some other places. But she could have donated to, say, No More, the domestic violence charity that was partnered with the firm. She could have done that. Length of jury trial. This case will be tried by a jury. Ms. Lively anticipates that the trial will take approximately 15 trial days. Defendants believe that fewer days will be needed for trial because the court's summary judgment order substantially narrowed the number of causes of action, the number of parties, and the issues relevant for trial. Defendants intend to raise their concern with Ms. Lively's position at the pre-trial conference. Plaintiff disagrees that the court's April 2nd summary judgment order substantially narrowed the witnesses and evidence to be presented at trial, which still must be introduced to establish elements of all of the remaining claims, all of which defendants continue to challenge. As such, plaintiff has included witnesses and evidence necessary to establish, among other things, that 1. She engaged in a protected activity, including that she had good faith, reasonable belief that unlawful harassment occurred. 2. She suffered an adverse employment action, including but not limited to through a retaliatory digital and media reputational character attack, which also, among other things, directly breached the contractual promise made to her not to take any negative action against her, including in connection with the press or the promotion of the film. 3. Her protected activity was a substantial motivating reason for the adverse employment action against her. 4. TAG aided and abetted that retaliation. 5. She was harmed. And 6. Defendant's conduct was a substantial factor in causing her harm. Joint statement of the case. Plaintiff's proposed statement. The case arises from Ms. Lively's claim that she experienced retaliation for complaining about or opposing what she reasonably, in good faith, believed to be harassing conduct in connection with her work on the film It Ends With Us. Ms. Lively was the lead actress and a producer on the film. Oh, you were a producer. You forced that, and it come in well late, like it was in June 2024. You did not start as a producer. Ms. Lively is suing 3 defendants: the movie studio that owned and produced the film, Wayfarer Studios, its subsidiary, It Ends With Us movie, and TAG, a public relations and crisis management services company. Ms. Lively alleges that Wayfarer and It Ends With Us movie retaliated against her for complaining about or otherwise opposing harassing conduct by Justin Baldoni, the co-owner and co-chairman of Wayfarer, as well as Miss Lively's co-star and the director of the film, and Jamie Heath, a producer of the film and CEO of Wayfarer and president of It Ends With Us movie. Miss Lively also alleges that Tag aided and abetted the retaliation against her. Each defendant denies Miss Lively's claims and alleges that Miss Lively was not retaliated against for complaining against Mr. Baldoni or Mr. Heath's conduct related to the film It Ends With Us. Defendants further allege that Miss Lively's claimed damages and reputational harm were not caused by defendants, but instead were the result of other factors. The case arises, so this is defendant's proposed statement. The case arises from Miss Lively's claim that she experienced retaliation following her work on the film It Ends With Us. Miss Lively was the lead actress and a producer on the film. Fine, they conceded it too, so I'm going to have to. Makes me angry though. So I'm going to concede that she was a producer under protest. Just saying. Miss Lively is suing 3 defendants: the movie that owned and produced the film, Wayfarer Studios, its subsidiary It Ends With Us movie, and TAG, a public relations and crisis management services company. Miss Lively alleges that Wayfarer and It Ends With Us movie retaliated against her for complaining about or otherwise opposing harassing conduct by Justin Baldoni, the co-owner and co-chairman of Wayfarer, as well as Miss Lively's co-star and the director of the film, and Jamie Heath, a producer of the film and CEO of Wayfarer and president of It Ends With Us movie. Miss Lively also alleges that TAG aided and abetted the retaliation against her. Each defendant denies Miss Lively's claim and alleges that Miss Lively was not retaliated against for complaining about Mr. Baldoni or Mr. Heath's conduct related to the film It Ends With Us, and defendants assert their actions were instead reasonably intended to protect Wayfarer Studios and It Ends With Us movie and their reputations from unfair and false attacks. Defendants further allege that Miss Lively's claimed damages and reputational harm were not caused by defendants, but instead were the result of her own conduct or other factors. Okay, so we've got a lot of names to go through of people, places, and institutions likely to be mentioned. Again, just a caveat warning, I'm not good with names. I am not good with names, so if I will say it how it kind of reads to me, and if I'm wrong, I apologize. That's all I can do. People: Jennifer Abel, Andrea Agemian, Kevin Alexander, Nicole Alexander, Ashley Avignon, Claire Ayub, Emily Baldoni, Justin Baldoni, Vivian Baker, Russell Barnes, Cynthia Barnes Slater, Gary Baum, Todd Black, Jerry S. Blackmon, Julie Bloom, Scooter Brown, Katie Case, Anne Carroll, Chelsea Carey, Andrew Chrysomalis, Aaron Carlotta, Eric Damon, Ashmi Dang, Ariel Emmanuel, that's Ari Emmanuel, Isabella Ferrer, Taryn Fisher, Shasti Fla, Una Flaherty, Jennifer Freyd, Anne Fromholtz, Ange Gianetti, Sarah Gallman, Danny Greenberg, Josh Greenstein, James Haggerty, Christy Hall, Tara Hanks, Jamie Heath, Natasha Heath, Matthew Hildzick, Colleen Hoover, Ashley Humphreys, Carolina Hurley, Stephanie Jones, Rosa Kalantari, Jeffrey Kinrick, Brianna Butler Coslow, Joseph Lanius, Sean Levy, Blake Lively, Riley Long, Danny McGinn, AJ Marbury, Richard Marks, Michael Marshall, Dina Maislin, Dervla McNeese, Amin Mezian, Hassan Minaj, Matthew Mitchell, Adam Monshine, Shoila Moore, Ahmed Muziol, Melissa Nathan, Sarah Nathan, Alex Neustadt, Young Atlas, I can never say his name, Stacey O'Neill, Emmanuel Nunez, Sanford Panich, Mark Persley, Barry Peterson, Liz Plank, Shekinah Reese, Shane Reed, Ryan Reynolds, Michael Robbins, Lisa Rogers, Elizabeth Rosner, Tom Rothman, Sarah Rule, Jill Sacco, Alex Sachs, Steve Saretz, Alex Seeley, Tatiana Sequel, Michael Sipple, Brandon Sklenar, Jenny Slate, Leslie Sloan, Justin Greystone, Sage Steele, Lindsay Strasberg, Dion Suleman, Chris Sargent, Taylor Swift, Elizabeth Talbot, or Liz Talbot, Lizzie Talbot, Laura Tedesco, Milicia Toskovich, Mitz Toskovich, that is, James Vituscka, really? Michael Wagner, Jed Wallace, Patrick Whitesell, Warren Zavala, and Finley Sotter. Okay, the institutions. Again, same caveat. Analysis group: Betty B. Holdings, Betty Booz Opco, Betty Buzz, Blakehall Inc., Columbia Pictures, De Moi, Entertainment 360, XT Inc., oh God, Family Hive, Gershon Lerman Group, Ilzik Strategies, It Ends With Us Movie, Jones Works, Market Cast, Maximum Effort, Mitchell Silberberg and Nup, Nuco Media Group, Paylocity Holding Corporation, Popcorn Planet, PRCG Haggerty, Producers Guild of America, RWA Communications, that's Jen Abels, new company. Well, say new, it's been going for a couple of years. Screen Engine, Skyline, Sloan Offer, Weber and Dern, Sony Pictures Entertainment, Street Relations, Tag, The Daily Mail, The New York Times, TMZ, Van Zandt, Variety, Vision PR, Volleyball, Wayfarer Studios, and William Morris Endeavour Entertainment. Places: 15 Exchange Place, second floor, Jersey City, New Jersey. 399 Jefferson Road, Troy Hills, New Jersey. 1001 Bloomfield Avenue, Hoboken. 575 West Side Avenue, New Jersey. 996 Hillside Avenue, Plainfield. Okay. Plaintiff's position. Plaintiff maintains that Brian Friedman and Lina Friedman, Titleman, and Cooley should be included on the list of people, places, and things likely to be mentioned because he and or they are authors or recipients of relevant and admissible communications that Ms. Lively intends to rely on trial. With respect to the defendant's assertion that this list should include Michael Gottlieb, Wilkie Farr and Gallagher, Sigrid Macaulay, Boyce, Schiller, Flexner, who are authors or recipients of relevant and admissible communications that defendants intend to rely on at trial. Plaintiffs note that the only documents on defendant's exhibit list that appear to reference Mr. Gottlieb or Ms. Macaulay are irrelevant and prejudicial. Defendants have no retaliation or any counterclaim for that matter that could possibly make relevant any statements Ms. Lively's representatives have made during the course of litigation. Well, no, that's not true. Plaintiff has objected to the inclusion of such documents on defendant's exhibit list and is also separately addressing these documents in her forthcoming motions in limine. By contrast, there are numerous communications referencing or involving Mr. Friedman and other counsel from Lina Friedman, Titleman, and Cooley that evidence retaliation against Ms. Lively, both in retaliation to defendant's retaliatory lawsuit and those which are not litigation related at all, including in the form of witness intimidation. Okay. Defendant's position. Defendants disagree. Defendants maintain that it would be unduly prejudicial to include Mr. Friedman and Lina Friedman, Titleman, and Cooley on this list and things likely to be mentioned to the exclusion of other counsel of record. If names of trial included on this list, and defendants request that the court also include Michael Gottlieb, Wilkie Farr, and Gallagher, Sigrid Macaulay, Boyce, Schiller, and Flexner, who are authors or recipients of relevant or admissible communications that defendants intend to rely on at trial. And obviously, with Sigrid Macaulay, it's kind of important, really, because in January she was saying, "Oh my God, this is all about." Sexual harassment. And then when the sexual harassment claims got thrown out, she was like, it has always been about the retaliation. It's like, that is actually important. The same as Nice Pool. Like, the reason that I'm telling you now, this is my opinion, but I firmly believe it. The reason that Wayfarer want to bring in Nice Pool, for instance, is it's not because there's a claim pending. And the judge threw out, as I said, when I went through the motions in limine, he threw out Nice Pool in the context of, it can't support a defamation claim against Ryan Reynolds because it's, because satire is protected speech. It's protected speech. So no. And plus, and he rationalized that, there may be other reasons why Ryan Reynolds chose to make some of the statements he did. And so therefore, but he did not preclude Nice Pool being brought in as part of a defense. He did not say, well, it's completely barred from this case ever. You can't mention it again. You can't show clips. That's not what he said. And he also blocked the discovery of, regarding Nice Pool with Marvel because he'd already dismissed the claim. And what he basically said was, which Lively again is misrepresenting, he said, well, this is now moot because, it's not relevant to any claims. But it's because he'd thrown out the defamation claim in which Nice Pool would have been relevant. But he was right to say there were no claims. Does not mean that Wayfarer cannot still utilize Nice Pool. Unless he says he agrees with the motion in limine, they can. And one of the things they're going to do is say, show the jury, because she's going to go in and say, oh my God, it was awful. She's going to have her husband probably say, oh my God, it was awful. I had to live with, watch her suffer. And Wayfarer are going to be like, okay, well, let's look at how you responded to that by making a big joke of it. And that's exactly when they want Sigrid Macaulay's statements as well. It's like, hold on a minute, everything was all about sexual harassment and how you're going to speak up for women. Now you can, now you can't, there's no claims about sexual harassment. It's always been about your reputation and how it got trashed and, no, because she can't then claim to be speaking for women if the retaliation is affected only her. I know what I'm trying to say there. At the moment, her concern, it's always been about the reputation and how my reputation was damaged, and what the world thinks of me. And it doesn't sound like she's speaking for everyone at that point. Same as her protections letter, a return to work, the contract writer. She claims it's for everyone, and she was doing it to protect the whole cast and everything. What else is there on that letter? Out of all those 17 points, what benefits the cast as a whole? I can't find anything. But it did benefit her PGA letter. Right. Okay. We let's continue. So now we're at the actual witness list. Right. Consent to trial by magistrate judge and stipulations. The parties do not consent to the trial of the case by a magistrate judge. The parties are separately addressed in stipulations. Okay. Trial witness. So this is a plaintiff's list, right? And she has put a footnote here to reserve the right to amend the list. Okay, so Blake Lively. She's going to appear live. So what's she going to talk about? Well, defendant's misconduct related to the film, responses to workplace complaints, post-production of the film, the film's promotion and marketing campaign, defendant's retaliation, aiding and abetting, and damages suffered therefrom. Okay, standard. She has to give testimony on that trial. It's her claim. Ryan Reynolds, though, this one confused me. I don't understand this. Because he was not deposed. she invoked spousal privilege regarding defendant's misconduct related to the film and post-production of the film. He was not there. He was filming Deadpool and Wolverine. You got to remember that the quote-unquote misconduct occurred during phase 1 of the filming. By phase 2, when he was on set, everything was fine. I mean, so what's he going to talk about there? There's not really anything to talk about. He can't talk about her distress because she's thrown out she herself threw out her own intentional and negligent infliction of emotional distress. She's only got garden variety emotional distress, which really should be limited to her own testimony and no one else's. So I'm confused here because everything else, spousal privilege is invoked. So what's he can't really, share any communications between him and Blake Lively, and Wayfarer can't get that out either unless spousal privilege gets waived. The marketing, okay, yeah, there may be something he could say about that. He was definitely there. We saw him in the junket with Brandon Sklenar. And Maximum Effort were kind of overseeing all of that. He is also the other 50%, owner of Van Zandt. Let's not forget that. Lively in her own motions in limine said, well, I own 50% of Van Zandt. I said, the company was formed between me and my husband. So he is the other 50%. He also became the CEO, didn't he? When it was the recent filings. There's a lot of information to take in, but he can't talk about what's he going to say about defendant's retaliation and aiding and abetting. He's got nothing he can say about that. Nor can he talk about her damages. Unless he's an expert, he's not. He can't really talk about her damages. So I'm confused by that. The only thing I can see him talking about here is the marketing. And then he's going to get crucified if he does that, because the first thing Wayfarer are going to say is, so was it a choice not to talk about domestic violence? Was it a choice to, to do a junket where you talked about jealous husbands, jealous best friends, jealous mother-in-laws, jealousy being a theme of, a common theme in domestic violence situations? Was it a choice for you to, put up a picture of Brandon Sklenar's backside and then, talk about it, ogle it? And then he very much risks as well. Like, if he does actually get to a point of, well, Mr. Reynolds, how did you feel about, when you heard that Mr. Heath stared at your wife while she was topless or breastfeeding or whatever story they decide to run with on the day? How do you feel about that? And then they're going to bring out, is it true that on the set of the, on the set of the, is it the change up? I can't remember. It's going to annoy me, so I'm going to have to go and get it. Yeah, it was a change up. Sorry. Right. So on the set of the film, The Change Up, you after the director had yelled cut, you grabbed hold of Olivia Wilde's naked breasts, and you yourself even referred to that as borderline sexual harassment. Mr. Reynolds, is it true that you once glared at a woman breastfeeding in a hotel lobby, and when in an interview you even said that if you could go back in time to any one place, you would go back to that? They're going to just start pulling out his own shit and making him look bad. And, well, you didn't have a problem with this when you were doing it yourself, but you have a problem with, Mr. Heath doing it to your wife. Mr. Reynolds, do you live by double standards? That's how that is going to go. It's a dangerous move, because if Wayfarer can get evidence of those of Ryan Reynolds' own past kind of things as rebuttal evidence, which they probably could, yeah, that could be a problem for Lively, as if she ain't got enough problems. Okay, Justin Baldoni, which is expected. So that's regarding misconduct related to the film's promotion, marketing campaign, post-production of the film, and defendant's retaliation and aiding and abetting. Same for Jamie Heath, same for Jen Abel, same for Steve Sarowitz. I mean, what's Steve Sarowitz going to... Really, what is he going to say about this? Because he wasn't really involved in it. You know, he might have been kept in the loop, but then that's technically hearsay. Katie Case regarding retaliation, aiding and abetting. Brana Coslow Butler, retaliation, aiding and abetting. Isabella Ferrer regarding defendant's misconduct related to the film. Right, well, she's only going to be able to talk about the things that she now believes are a problem, which at the time she didn't think were a problem. She only thinks that they're a problem because Lively's told her they're a problem. She might be able to say something about the marketing of the film, possibly. And that's going to be, well, you know, it's going to be the fact that she was lied to about by Lively, that, you know, oh, well, Wayfarer didn't want us to talk about DV, and then they went and talked about DV and it just made us look bad. No, Lively didn't want to talk about DV. Sony, and she pushed Sony and WME to make that happen. Sony didn't want to talk about DV either because apparently DV doesn't sell as much as sex. And Sony wanted, you know, the sex elements of It Ends With Us, but they didn't really want the DV side of it because it's a bit of a downer to talk about. Lively's damages. What can she say about Lively's damages? Jenny Slate, I mean, is literally the one witness who actually saw something, because Isabella Perez saw nothing. She wasn't even on set with any of Lively's when any of Lively's alleged harassment took place. So she saw nothing, and she's not bringing a claim against Justin Baldoni for anything that she now believes after the fact to have been harassment. And out of the three things that she come up with in her deposition, one of them was hearsay. It wasn't said to her. The other was said to both her and her male co-star. So it was not like it was not, you know, harassment related to her sex or gender. And I can't remember what's the other one? Licking the spoon, the cookie dough off the spoon. Well, that is in the book. It's in the book. And then Wayfarer are going to predictably bring out that they're going to bring out that Instagram post, the marketing. So from the top of my head, right, one thing that Isabella Ferrer brought up in her deposition was "oh, that was so hot" comment. Oh, I can't remember everything off the top of my head, but that was said to both her and young Atlas, because I can't say his name. So there's no sexual harassment there. Then there was the comment that to young Atlas by Justin Baldoni, allegedly there was a conversation which she was not part of and did not learn of until months later, that he had, you know, suggested that that Justin Baldoni had suggested that he, you know, get to know her, become friendly, and, you know, ask her out, which apparently happened because they're now dating. But I mean, that's hearsay. It's hearsay, and it's completely irrelevant. It's not really sexual harassment either, you know. It's just stupid. Then the third one was you licked cookie dough suggestively while staring into someone's eyes. I mean, the licking of the cookie dough doesn't seem to be the problem. It was the fact that she had to stare into the co-star's eyes, which was weird. But I'll tell you what Wayfarer are going to do. They're going to go to this post. They're going to bring up this, and they go, "Miss Ferrer, is this you? Is this sexual harassment?" That's what they're going to do. They're going to be like, you're talking shit. You're clearly not bothered by this. You were happy to do it for Blake Lively. Why have you suddenly got a problem doing it for, you know, as part of the film, a scene which is actually in the book, and you've got an issue with it? So, again, risky. I'm not going to spend time doing this with every single one, but I actually could do that because there is problems for every single one. Jenny Slate witnessed something. Okay, maybe she has something to do with it. But then they're going to say, "Miss Slate, were you offended that Wayfarer paid money to upgrade your accommodation because they referred, because they basically said that they refer, because you're a mother, you were given some importance here, and you found that patronizing. Do you want to explain your logic behind that? And that's going to piss people off. That's going to piss people off. Because there are going to be a lot of mothers, and some of the jury may even be mothers, and they'll be sitting there thinking, wow, you ungrateful bitch. It just seems so petty. Because it was clearly a well-meaning gesture by Jamie Heath. And for her to get her fucking knickers knotted over it, I think it will demonstrate to the jury the level of pettiness and how fragile these women were around men who try to be accommodating. And it is not a flex for women to be stamping on nice men. That is not a flex. That's not being a strong woman. So she's a risk. Warren Zavala. I mean, what can he say about misconduct related to the film? It would be hearsay. The promotion and marketing campaign, again, what? Defendant's retaliation and aiding and abetting. He has no knowledge of that. He's got no personal knowledge of that. Lively's damages. He might be able to say something about that, but not too much. Leslie Sloan. Okay. I mean, there are text messages from her as well, where she is clearly smearing and lying. So that's not going to go well. Lizzie Talbot, regarding practices related to scenes involving simulated intimacy, nudity, and other vulnerable or hyperexposed circumstances, including the defendant's failure to adhere to the same. Great. Now, here's the thing that bothers me. Is the rules today are not the rules that were in place at the time. And at that time, they had nudity riders. Lively didn't want to sign hers, right? But showing a hip, I just find that ridiculous. That's been regarded as nudity. But having an intimacy coordinator, they had one, but it was not mandatory. It was a recommendation, but they had one. And Lively had the right to say no to scenes that she did not want to do. She did the scene. In fact, Wayfarer are arguing that she wrote the scene. So the issue, I'm not sure. And again, she would get pulled apart. She'll be Miss Talbot. If someone like Miss Lively is to simulate nudity during a birth scene, what color would the fabric be between her legs? And she will say it's nude, obviously, to basically fit with her skin tone, because it's supposed to be implying nudity. And then they will be asked, well, why was she given a fabric piece of cloth? What, a black one? Why was she given a black piece of fabric for that purpose then? Why would they use a black one? That doesn't make sense. That's not the same skin tone as her. And when I say black, I mean jet black. I don't mean like, blacks, like a skin tone of a black person. I mean jet black. And she was like, she will struggle on that. And then you'll have Adam Monshine will probably come in then afterwards and say, yeah, she was wearing underwear. But you need to remember that the rules changed after that scene where they were tighter. But at the time, there was some recommendations, but there was no requirement actually for anything. And I think this is a bit that Lively keeps forgetting, but she also seems to keep forgetting that, in her agreement, in her, I think in her loan out agreement, she had the right to veto things that she did not want to do, she was not happy with, she was not comfortable with. I mean, this woman had the right to veto Justin Baldoni being the co-lead actor or being a director. That's the level of power she had. So if she did that scene, she was not forced to do it. She did it because she wanted to do it, because she did write it. I think they're going to have a problem there. Kevin Alexander, I'm not quite sure who that is. Oh, is that security or a driver or something? Regarding harassing statements made by Mr. Baldoni to Miss Lively. Is this about the dead dad? Stephanie Jones, are we serious? Stephanie Jones, regarding defendant's misconduct related to the film. What does she know? She was not there. Anything she heard about was hearsay. There are messages of her referring to Lively and Slate as overly sensitive, weak, fragile women. I mean, she really had no patience for them whatsoever. So what is she going to say? And the retaliation and aiding and abetting, however you spin it, it was her company. Even if Blake Lively proves her claim and proves that Wayfarer did retaliate and do a digital smear campaign, they didn't. But even if she proves it, Jen Abel was her employee. And she can say, Stephanie Jones is going to go and say, well, they kept me out of the loop. No, they didn't, actually. And I think there'll be evidence there to prove that she wasn't. Betty B. Holdings and Family Hive, damages suffered by Miss Lively. But they can only show damages that they themselves suffered. And she's got no stand-in to bring these claims. Alex Sachs, regarding defendant's misconduct. She saw nothing. Ryan Reynolds asked her to go on record, and she said she declined because she didn't actually witness anything. So there's nothing for her to say. The response to the workplace complaints and post-production of the film, etc., etc. I mean, there will be some stuff that she can talk about. How useful it is, I don't know. Vivian Baker, regarding defendant's misconduct related to the film, same as Anne Carroll. That's Lively's hair and makeup artist. So they can talk about possibly the trailer incident, but they have different accounts. So they will get pulled apart. Colleen Hoover, regarding the film's promotion and marketing campaign and defendants' retaliation. Colleen Hoover was told defendants were retaliating by Ryan Reynolds. She was told. She had no idea. There's a whole long text message from Ryan Reynolds to Colleen Hoover telling her, oh, this is retaliation. So all she's going to do is give, hearsay from Ryan Reynolds. But yeah, she could talk about the promotion, marketing, and everything like that. But she can also, that will work as well for Wayfarer, because Miss Hoover, who did you recommend Mr. Baldoni to play Ryle? That's you can talk about other things. Miss Hoover, did you feel pushed to support Blake's cut? Miss Hoover, why did you unfollow Justin Baldoni? Miss Hoover, who told you that Justin Baldoni said that you were from the Baha'i faith? Who spread that rumor that upset you so much? Did you hear it from Justin Baldoni himself? I could go on a tangent. Josh Greenstein, post-production of the film's promotion and marketing campaign, defendants' retaliation. I mean, he can't speak to retaliation. Miss Lively's damages, he can't speak to that either. But to post-production of the film and the film's promotion, Mr. Greenstein, were you aware that, Lively had called upon her friends to basically go after Tom Rothman and demand that her cut win? Justin Greystone, that's Lively's manager. Again, he can't speak to the misconduct on the film. I'm not sure what he can say about post-production, or the film's promotion and marketing campaign, or retaliation. He might be able to say something about Lively's damages. Jed Wallace, retaliation and aiding and abetting. Liz Plank. I mean, what the fuck is Liz Plank going to say? She wasn't on set. She can talk about her experience with defendants, but the first thing she'd be asked is, well, why did you work with them for so long if they were that awful? And she wasn't, with her, it wasn't just like, 2 weeks worth of days. It like Lively, was it 16 days? I think she worked with Justin Baldoni actually filming. Liz Plank was a co-host with both Jamie Heath and Justin Baldoni for years, right? And the other thing they're going to say is, "Oh my God, are you Liz Plank?" Potentially, if they can get this in again as rebuttal, Liz Plank, are you really grossed out by harassment? Do you believe that people should be touched, their bums should be touched? Is that sexual harassment to you? Really? And then they might wheel out some clips of her doing that, running up to random men and sexually harassing them to make a point, which I'm not even sure what point she was making, because the men she was grabbing weren't sexually harassing anyone. But she's an idiot. Claire Ayub, really? Regarding the conversation with defendant Steve Sauritz. Robin Lively, regarding defendant's misconduct related to the she didn't see anything. She also can't speak on retaliation, and she can't speak to Lively's damages. And if we're talking about emotional distress, they can't talk about this. If when we say damages, because I'm thinking, oh, this is going to be like lost profits and loss of opportunities. But now I'm thinking about it, the only thing that any of these people, the co-stars, the manager, and all that can really talk about in terms of damages is how upset she was. But they can't all sit and do that because she's only claiming garden variety. James Vituscka. Now we're really scraping the fucking bottom of the barrel, right? People will know my opinions vividly on James Vituscka. Anyone who's watched my videos for long enough will know how I feel about James Vituscka. James Vituscka being called as a witness to discuss anyone's honesty and integrity is just, it's the ultimate April Fool's fucking joke. There's a guy who's changed his story more times than he's changed his legal team, and he's done that a lot too. They're going to pull him apart, right? Because there are those. Yeah, okay. He's put out declarations saying, "Oh no, they took my words out of context, blah blah blah." And they knowingly put out my stuff, even though I told them I didn't see anything. No, Leslie Sloan didn't say anything, blah, 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 blah. But there are also the messages where he's telling Melissa Nathan that Leslie Sloan is a liar, that Blake Lively is a liar, that Stephanie Jones is the worst. And, his declarations say, oh no, I never said that, I never gave him permission to use my text messages. His messages with Melissa Nathan do the complete opposite and confirm that actually he did. This guy is just ridiculous. And I don't know why anyone thinks he's going to be a credible witness, because the first thing he's going to do is demonstrate that he is absolutely not. Aaron Westerman, I don't know, regarding misconduct on the film. I don't know who is Aaron Westerman. Eden Sharman, I think, is like some kind of friend PR. I think some of these are now Lively's staff. I know Sophie Travaglia is. And then we got the experts then. Experts regarding damages, conduct, betrayal, trauma, DAVO, human resources, blah, 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 blah. Now we get to Wayfarer's list. So Justin Baldoni, regarding his role and responsibilities on Ends with Us and as a principal of Wayfarer Studios, his interactions with Lively in connection with pre-production, production, post-production, the promotion and marketing of the film, and publicity relating to the film and Lively. Jamie Heath. Same, pretty much. his role as responsibilities on the film as CEO and as a producer, I'm guessing, his interactions with Lively, pre-production. Jamie Heath would be able to say, oh, yeah, I was threatened by Josh Greenstein. I was threatened. And he was threatened, by the way. So, that was over the Taylor Swift song and, removing Justin Baldoni's a film by credit and so on and so forth. Jen Abel, just regarding her role as publicist, the promotion and marketing campaign. Now, she's going to be quite important, I think, because she's going to be the one who's going to explain, the fight that she had to put forward to try and get Justin Baldoni involved in some publicity whilst everyone else was icing him out. Melissa Nathan, so that's going to be about the crisis, PR, etc., etc. Blake Lively, regarding Tag's engagement by Wayfarer Studios to perform crisis management. Oh, I think they've copied and pasted that. That's not what it should be. I think they've copied and pasted from Melissa Nathan. I don't see what Lively's going to know of Tag's engagement. Adam Monshine, regarding his role on the film, his experience and qualifications as an actor, because Lively was saying, well, he's not an actor. And he was. And his interactions with Lively, including in connection with the birthing scene. Well, that would be the witness I would be sitting waiting to hear from. Because he's not had a voice pretty much throughout all of this, even though he's been dragged through the mud. His reputation's been dragged through the mud. And he was the one person who was within sniffing distance of Lively during that birth scene. So, yeah, I want to hear from him. Katie Case, Brianna Carslow, they're about the promotion, marketing, and publicity. Ashmi Dang, regarding the film's promotion and marketing campaign. Shasti Flower, regarding her interview of Lively, and Flower's republication of that interview in 2024. Michael Wagner, Nicole Alexander, Emmanuel Nunes, and James Haggerty are all witnesses, expert witnesses. Then Vivian Baker, regarding her responsibilities on the film, her work history with Lively and Reynolds, her interactions with Heath and Baldoni, including an interaction with Heath in the May 2023 in the makeup trailer and the film in the birth scene. Shelley Ann Carroll, regarding the her interactions with Heath Baldoni, her work history with Lively, the Heath in the makeup trailer and the filming of the birth scene. And Giannetti. Find it interesting that, by the way, that Lively is not calling Ange Giannetti. Regarding her involvement with the film, Sony's role, her interactions with Heath Baldoni, Lively, and other cast members, the marketing campaign for the film, and the publicity for the film and its cast. Now, what this is telling me, the fact that Wayfarer calling her, but Lively isn't, is that she is more favourable to Wayfarer. Now, Wayfarer got Josh Greenstein on their list, as Lively does too. And don't forget, Josh Greenstein was the bumbling mess who kept pandering to Lively from Sony. But it was Ange Giannetti who was on set. Ange Giannetti is not being called by Lively, despite being the one that Lively named in the 17-point demand list as the Sony representative she wanted on set. Does anyone find that interesting, or is it just me? Why? Because Ange Giannetti saw the birth video as well, Jamie Heath's birth video, and said, it was nothing. Didn't find it offensive. Ange Giannetti is also one who said Jenny Slate didn't, was content that her problems were resolved to her satisfaction. She did not think it was sexual harassment. Ange Giannetti is the one who was in that who has called Blake Lively a terrorist, along with Sanford Panich. But Blake and Giannetti has also called Blake Lively a terrorist. And I find it fascinating that we have gone from a position where, in the 17-point list of demands, Lively wanted Ange Giannetti to be the one on the representative on set. She was also the Sony representative who was in the apartment meeting, the penthouse meeting, right? Josh Greenstein wasn't. I'm just going to double check that she's not on there, actually. Yeah, Ange Giannetti. Oh my god. Yeah, Ange Giannetti is not one of Lively's witnesses. I just wanted to double check that in case anyone would come back to me and said, but Leanne, she's there. And I just forgot about it. Right. So she's not. But she is the one with all the information. It's just not information that's favourable to Lively. So that's why she's there. Daniel Greenberg. Okay, so that is Justin Baldoni's former agent at WME. And he's going to be there to talk about his role as Baldoni's agent, his interactions with Lively's agent, Warren Zavala, in connection with the film. Josh Greenstein, regarding his involvement with the film and Sony's role in the marketing and promotion of the film and the publicity relating to the film and its cast. It'll also be Josh Greenstein, did you bend over every time Lively told you to? Did she offer any lube? It'll be that kind of sorry for the kind of graphic there, but I'm trying to place emphasis on the kind of questioning that they're going to apply to Josh Greenstein, is that he was basically Lively's puppet from Sony. Not all of his views of Lively were positive. He talked shit about her a bit as well. And there were certainly evidence as well, because Ange Giannetti and Sanford Panich discuss it in their text messages, where Josh Greenstein was kind of bullied and coerced to do stuff as well for Lively. I mean, I don't know what use he's going to be as a witness, though, because throughout his deposition, he was like, I can't remember. I can't remember. I can't remember. I was like, why are you even here? Like, and how could you forget all of this? Honestly, all of this drama goes down, and how could you forget it? Justin Greystone, Lively's manager, regarding his interactions with Lively in connection with the film and issues relating to Lively's allegation of retaliation and her purported damages. Colleen Hoover, regarding Lively's request that Hoover unfollow Baldoni on social media. And once you get one, you start to get them all. It at least calls into question. Alex Sachs, regarding her responsibilities on the film, her interactions with Baldoni, Heath, Giannetti, and Lively, and her observations of conduct on a set, which will be a very brief, part of the questioning, because she saw nothing. She didn't actually see anything. People spoke to her, but she didn't actually witness anything. Elizabeth Talbot, regarding her role and responsibilities, the function of an intimacy coordinator, her interactions with Baldoni and Lively, sex and nudity scenes proposed for the film, and her absence during the filming of the birthing scene. And then we got Warren Zavala, regarding negotiations for Lively's appearance in the film, the film's promotion and marketing campaign, and the publicity during the pre-production, filming, editing, and marketing and promotion of the film. Okay. I just want to go back a minute because I can't remember. Alright, so Christy Hall isn't on here at all for anyone? Because I would have liked to have seen her on there, like Miss Hall, the rooftop scene. How did it feel when you found out that Ryan Reynolds wrote it? Did it shock you? Were you expecting Blake Lively to have written that because that's what Blake Lively said she was going to do? All right. Defendants believe that given the court's April 2nd summary judgment order, many of the witnesses are no longer relevant. Ms. Lively disagrees. Defendants intend to raise their position at the pre-trial conference. Deposition designations. A compendium of charts reflecting the parties' deposition designations, counter designations, counter designations, and objections is attached here to as Exhibit A. Exhibit A includes the plaintiff's affirmative deposition designations for the following witnesses: Vivian Baker, Anne Carroll, Josh Greenstein, Julian Gray Stone, Colleen Hoover, Alex Sachs, Elizabeth Talbot, Jed Wallace, and Warren Zavala. So those are the ones who are going to appear by deposition. Everyone else is appearing live. Exhibit A includes defendant's affirmative deposition designations for the following witnesses. So these are Wayfarer's deposition designations: Vivian Baker, Anne Carroll, Andrea Giannetti, Danny Greenberg, Josh Greenstein, Justin Gray Stone, Colleen Hoover, Alex Sachs, Elizabeth Talbot, Warren Zavala. Defendants believe that given the court's April 2nd summary judgment order, many of the witnesses are no longer relevant. Miss Lively disagrees. Defendants intend to raise their position at pre-trial conference. Okay. So we've not got too much more to get through now. Okay. Miss Exhibit list. I'm not going to go through them. They are very long. I'm not going through any of the attachments. They're incredibly long, and there's not much information I could go through with someone who has not spent years learning how to do this. It is incredibly complex. So I'm not going to do it. I might do it, once I've got through the rest of the filings. If I get some time and I can find a way of putting it into simple, plain English, then maybe. But right now, I'll show you what it looks like, and you'll see why. So Miss Lively's exhibit list is attached here to as Exhibit B. We can flick through that because there'll be stuff that'll be there, like the text messages and all that with the various base numbers, but then there'll be like titles of articles. That might be interesting. We can do that. Defendant's exhibit list is attached here to as Exhibit C. Defendants believe that given the court's April 2nd summary judgment order, many of the documents on both parties' exhibit list are no longer relevant. Miss Lively disagrees. Defendants intend to raise their position at the pre-trial conference. And I will be joining that pre-trial conference if they make it a public thing. I think they will. These phone-in things, the sound quality is awful. It's incredibly hard to hear anything or know who is talking at any given moment. And especially for me, because I have to pay because I'm international, it costs an absolute fortune. I don't care about that, but and I will attend anyway. But if that option is there, but it is to manage your expectations, it can be very difficult to hear. So I'll do my best. Per the court's instructions, the parties have indicated with one asterisk exhibits to which no party objects on any grounds, subject to any objections that may be developed depending on how the document is used at trial, with the caveat that defendants have not yet been able to review the dozens of new exhibits. Miss Lively identified for the first time this morning this filing was due. Defendants will provide an additional response to those exhibits in due course. In turn, Miss Lively reserves the right to provide additional responses to the exhibits that defendants identified for the first time on the evening this filing was due. Before I go to damages, though, I just need to go back up a minute because I don't want to go too far down. Lively's witness list. There is something here that bothers me a little bit, and I suppose it's more of a question. I'm thinking out loud. Jen Abel was appearing by deposition. All those text messages, though, that came from Jen Abel's phone, she is supposed to kind of, confirm the authenticity. Like we saw it with the Johnny Depp Amber Heard trial where, Amber Heard was shown a photo that she admitted that she supplied as part of her evidence, and she had to say, do you recognize this? can you confirm that this is correct? Can you confirm that that's what this, like, here's the title of a news article. Can you confirm that? And she would say yes. And then, and only then, it would be entered into evidence. If Jen Abel is not there in person, though, how is that going to? I'm not sure how that's going to happen unless. I mean, Stephanie Jones is going as a live witness. Maybe they're going to deem us a. I think Lively's going to try to do that. I think Lively has to really do it as Stephanie Jones, because otherwise they'll say that would be basically conceding that the text messages from Jen Abel's phone belong to Jen Abel, whereas she's going to say, "Well, I got them from Stephanie Jones." Stephanie Jones is absolutely going to be asked about Van Zandt. I'm telling you now, but I'm guessing that just Stephanie Jones is going to be the person to say, as it was a Jones Works issued phone. It depends how that sits, and really we do need the court to kind of say who the text messages effectively belonged to, because it was, whilst the phone was a Jones Works phone, it it was also being used for the dual purpose of a personal phone as well. So Stephanie Jones does not get to own text messages between Jen Abel and her parents. That's not how that works, and that's not how it should work. Melissa Nathan, how would that work? I don't know. And it's just yet another of my thoughts, like questions that need to be answered. Okay, so we're on to damages now. Plaintiff Ms. Lively, relying largely on expert opinion for the method of calculation, seeks compensatory damages in connection with the claims to be tried by the jury, plus punitive damages. As for Ms. Lively's economic damages, as set forth in Ms. Lively's fourth amended initial disclosures and subject to expert testimony, Ms. Lively has suffered lost earnings between approximately $34,300,124 and $87,793,592 as a result of the defendant's conduct. Specifically, experts have calculated that Miss Lively suffered lost earnings as a result of 1. Lost acting and/or producing opportunities for major studio feature films from August 2024 through August 2029. 2. Lost acting and/or producing opportunities for independent, limited budget and cameo films from August 2024 through August 2029. Through August 2029. 2029. Why has she lost it through to why? I'm confused. I'm guessing that's not a typo, but I'm trying to think of why it would be so far into the future. Like, we're not even in August 2026. How is she holding Wayfair responsible for opportunities that she has not had 3 years into the future? I'm confused, and I hate my screen sometimes. 3. Lost acting and/or producing opportunities for limited television series from August 2024 through August 2029. I don't understand that. And what television series has she been part of ever? Apart from Gossip Girl, which was 30 years ago? And 5. Lost endorsements, speaking engagements, and personal appearances from August 2024 through August 2029. Yeah, but you had an award from Times 100. She's promoted a film since all of this. She's won an award, which probably got bought. I mean, she's had. I reserve judgment. Ms. Lively also seeks lost profits, as set forth in Miss Lively's fourth amended initial disclosures and subject to expert testimony, Miss Lively has suffered lost profits between approximately 39.6 million and 143.5 million. Expert testimony indicates that Miss Lively suffered lost profits and lost royalties through ventures Blake Brown Beauty and Betty B Holdings as a result of defendant's conduct. Miss Lively additionally seeks damages for the harm incurred to her reputation. Subject to expert testimony, Miss Lively has suffered reputational harm due to the artificial spread of the terms bully, mean girl, and tone deaf associated with the retaliation campaign. What? She had a reputation for being a bully and a mean girl long before this film, and tone deaf. I can't even come up with an alternative descriptor for her own actions that I witnessed in real time. Following the onset of the retaliation campaign, online and traditional media that associated Miss Lively with those terms generated over 176 million impressions, and the perpetuation of retaliatory and harmful statements regarding her legal complaints and defendant's retaliatory lawsuit generated over 116 million impressions. Reputational harm is not required to be quantified. Accordingly, Miss Lively will seek at least at minimum $40 million in connection with harm and upwards in an amount that the jury deems proportionate to the harm to Miss Lively's reputation, found to be attributable to defendant's retaliatory conduct. She wasn't even worth 40 million. Before she signed on to the film, she was not worth that. How can she say that, this has caused damage to that effect? Miss Lively also seeks damages for the pain and suffering, physical pain, and humiliation she suffered as a result of defendant's conduct. As set forth in Miss Lively's fourth amended initial disclosures, Miss Lively has suffered pain and suffering, physical pain and humiliation in the range of $250,000 and $400,000. Miss Lively has disclosed computations in relation to such figures in her fourth amended initial disclosures and in underlying expert reports and testimony. Defendant's position now. Defendants seek a verdict of no liability and a dismissal of the case with prejudice. Defendants note that based on her fourth amended initial disclosures, Miss Lively seeks total compensatory damages between $142,276,223 and $296,668,859. Defendants dispute Miss Lively's statement that she has disclosed computations in relation to such figures in her fourth amended initial disclosures, and contend that Miss Lively lacks standing to assert reputational harm damages to her business. Defendants will be moving to preclude several of her experts under Delbert, undermining the basis of her claims. Defendants further note that Miss Lively dismissed with prejudice her claims for anything beyond garden variety emotional distress damages. In addition, Miss Lively waived the right to seek reputational damages as set forth in defendant's motion in limine. Finally, several categories of damages Miss Lively seeks are not available for her contract claim. So I just to sort of say, Wayfarer pushed for when Lively agreed to dismiss her intentional infliction of emotional damages and negligent infliction claims, she didn't want to dismiss with prejudice, and Wayfarer were like, well, no, I'm not doing it. And they categorically stated, we believe that she will try to resurrect them at the last minute, after discovery's closed, blah, blah, blah. And it seems like they were kind of right. She is seeking to bring in evidence that would be of the level of a intentional infliction of emotional damages claim. You're bringing in all these witnesses to talk about her mental health and, what it did to her and how she suffered, bringing in all these experts, and then she's wanting to claim damages that are above. I think garden variety damage, emotional distress damages are between $5,000 and $30,000, but she is seeking between, what was it? It was like between $250,000 and $400,000. So yeah, I think Wayfarer back then hit the nail on the head, and they were right to push her to, and she did eventually dismiss those claims with prejudice, which means she cannot bring them back. And yet she still seems to be trying to get in the evidence for it, but she can't testify to that level. So yeah, brilliant. So unanimous verdict. The parties do not mutually consent to a less than unanimous verdict. So they're not agreeable to like a majority. Okay, so that is that. That was an interesting read. I did have a lot to say about that, so I hope everyone was all right with that. Voir dire, I think, and jury instructions is my next planned video. All right, guys. Please don't forget as well, if you could, to like the video, give it a little hype, and subscribe to my channel. All helps. Thanks, guys.